Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS extension 100 or visit yourrights.com.
مكاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات. قبل أن تختار المحامي الذي سيدافع عن قضيتك، دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. مكتب المحامية جومانا كيروز يعلن عن استقبال الموكلين والمراجعين في العنوان الجديد 24370 North Western Highway Southfield على مسافة قريبة من موقع المكتب القديم. مكتب المحامية جومانا كيروز يتعامل مع كافة قضاياكم المتعلقة بالإصابات الشخصية من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، بالإضافة إلى قضايا الهجرة والتجنس، الإفلاس، الضمان الاجتماعي وقوانين العائلة، والاستشارات مجانية. 248-557-3645. برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. أسعد الله أوقاتكم بالخير مستمعينا في كل مكان، وأهلا بكم في حلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز. بإمكانكم المشاركة في هذا البرنامج عبر الاتصال على الأرقام 313-769-6666 519-256-1023 ودائما عن طريق الواتساب 313-327-7074. كما بإمكانكم الحصول على استشارات مجانية في الاختصاصات التي يتعامل معها مكتب المحامية جومانا كيروز، وهي قضايا الإصابات الشخصية من ضمنها حوادث السيارات، قضايا إصابات العمل والأخطاء الطبية، قضايا الهجرة والتجنس والإفلاس، قضايا الضمان الاجتماعي وقوانين العائلة. 248-557-3645. أيضا ننوه أن مكتب المحامية جومانا كيروز انتقل إلى العنوان الجديد 24370 North Western Highway في مدينة ساوثفيلد. كما نذكركم بأن حلقات برنامج يور رايتس موجودة على اليوتيوب. كل ما عليكم هو زيارة قناة جومانا كيروز على اليوتيوب لمشاهدتها مرة أخرى. تحياتنا لكم جميعا ورحب بك جومانا في هذه الحلقة من برنامج يور رايتس.
صباح الخير داني، مساء الخير، مساء الخير للجميع. كيفك اليوم؟
الحمد لله، نسأل عنك دائما. إن شاء الله تمام.
كتر خير الله. مساء الخير لكل المستمعين. نحن صرنا عم نقلب الاستضافات مع المحاميين جياسو وهاورد رادنر من نهار الأربعاء اللي كنا نعملها بالمعدل مرة بالشهر، شهر ونص، لنهار الخميس، لأنه بنحب نستعمل كل نهار أربعاء لنحكي عن حوادث السيارات وقوانين حوادث السيارات والسلامة حول القيادة. اليوم مستقبلين آخر مرة استقبلناه يمكن من 5 أسابيع المحامي هاورد رادنر اللي عنده أكثر من 40 سنة خبرة بقضايا الانزلاق، slip and fall، trip and fall، ومكتبنا بيتعامل مع مكتبه بكل هيدول القضايا. من الملفات اللي بدنا نهنيه فيها اللي حصل على تسوية هائلة فيها هي لتوكل من موكلينا. ما بدنا نعطي كتير معلومات دقيقة لحتى ما يعني نعطي كلوز مين هذا الشخص. هو رجل، نعم رجل من الجالية وتعرض لانزلاق، والمحامي هاورد رادنر قدر عمل له تسوية من 10 أيام أسبوعين بشوي أقل من $900,000. بدنا نهنيه وبدنا نسأله يخبرنا شوي عن شو أول شيء ضد مين كانت الدعوة، وثانيا شو الفاكتس تبع الكيس اللي أهلوا إنه يقدر يحصل على تسوية من هيدا النوع. فبنستقبل المحامي هوارد رادنر ليلي عنده أسئلة اليوم بقضايا الانزلاق. مؤخرا كان عندنا كتير سنو أند آيس، لا سمح الله إن شاء الله ما حدا يكون تأذى، ما حدا يكون وقع، ما حدا يكون زحط. أي أسئلة أي من المستمعين عندهم إياها للمحامي هوارد رادنر لمدة ساعة 313 769 6666 313 327 7074. اجينا أول سؤال من السيدة حنان. خلينا نستقبل المحامي هوارد رادنر، نجاوب على السيدة حنان وبعدين نهني على التسوية تقريبا $900,000. Good afternoon, Attorney Howard Radner. How are you?
Good afternoon, Joumana. It's a pleasure to be with you again.
Pleasure to have you again. And before we congratulate you on your recent close to $900,000 victory for one of our clients, let me begin by answering a question we just received via our radio WhatsApp. And we encourage everybody to send us their questions if they don't want to call or to call. The numbers to call are 313-769-6666. And the radio WhatsApp is 313-327-7074. Miss Hanan states that she was injured at a family member's home. That's not her home. A member of her family. She got injured at that member of her family's home, but she does not want to sue them. What can she do with any cost that she may have incurred? I assume maybe medical cost, and who knows, maybe some other costs or expenses or loss of revenue as a result of her injury. So, can you go ahead, answer the question, and then
Sure.
we're going to break it down for Ms. Hanan.
Sure. In many homeowners insurance policies, there's a med pay provision, and that basically says that if somebody is injured on the property, the insurance company will pay for the medical expenses up to a certain amount. It may be $1,000, it may be $5,000, it may be $10,000, but that would be the extent of their coverage. And an interesting part of Michigan law is that you cannot compel the insurance company to pay if they choose not to. It would take probably an hour to explain why not, but suffice it to say that it's really up to the discretion of the insurance company if they want to pay for those medical bills. The only way to force
Do you have to prove negligence to get these?
No.
Okay.
No. Anybody that falls even due to their own fault on somebody's property, if the homeowner has that provision, and many policies do have it, I know I have it on mine, that the insurance company says that they will, in their discretion, pay the medical bills. And oftentimes they will. But it's very limited. It's only, like I said, maybe $1,000, maybe up to $5,000, sometimes 10. But there's no provision in that case for paying for one's loss of wages or his pain and suffering. In order to get pain and suffering and wage loss, then the injured party would have to sue the homeowner and prove the homeowner was negligent.
Let's break down Ms. Hanan's question. The first thing is, she wants to know, we need to talk about what costs are covered. Ms. Hanan, the greatest majority, but not all homeowners insurance policies have a portion that will cover up to a certain dollar amount only. It can be up to $1,000. It can be up to $5,000. Some homeowners buy up to $10,000. So if there is a provision in your family member homeowner's insurance for covering your medical bills because of your fall at that family member, then you can invoke that. That assumes, one, your family member has homeowner's insurance. Two, it's homeowner's insurance is like car insurance. Two, you will be getting that money not from your family member, who you made very clear you don't want to sue or hurt, but it will be from his insurance company. That's why people buy insurance, so that if there are payments to be made, the insurance company for whom you pay monthly a premium to be there for you will pay. It's called med, which is short for medical. Med pay, MED, D like dog, med pay or medical pay. If your family relative, one, has homeowners insurance, and two, has the kind of homeowners insurance that has medical pay or med pay, then you can submit your medical bills to your relatives' homeowners insurance to pay. You do not have to prove that your family relative was negligent. This isn't like when you are suing under the homeowners insurance. This is just for medical pay. Places like Meyer and Kroger and Target, because they have a lot of volume in their insurance policies, they have bigger medical pay, I suppose, per person, and no questions asked as far as liability. The insurance company is required to pay it. Like Attorney Howard Radner said, every once in a while, an insurance company, for whatever reason, will not accept those bills. Maybe it wasn't because of the fall, maybe it preceded the fall. But generally speaking, just so that we don't go into, every reason why an insurance will not pay, generally speaking, if your relative has homeowners insurance, look inside that declaration page. It's like a car insurance declaration page to see what your relative bought, and if there is a medical pay provision, up to how much? 1,000. I have seen 2,000 or 2,500, 5,000. I have rarely seen 10,000, but it can happen. Now, Attorney Howard Radner, let's say that Hanan also had to take 3 days off work and there is loss of income. Is that the kind of thing a homeowner's insurance policy will cover? Because her question is very general. She talked about costs. Somebody can be injured at somebody's home and take time off work, need to buy durable medical equipment, have medical expenses, have a deductible, have a copay. So can you clarify what is required of a homeowner's insurance in the event that there are out-of-pocket expenses?
Yeah, the med pay will only pay for medical expenses, Joumana. It will not pay for wage loss. In order to collect wage loss, you would have had to sue the homeowner in a negligence case.
All right. So the negligence case is you alleging that the homeowner, your family relative, was negligent. Your relative will not pay. His or her insurance company will defend him, hire a lawyer for him. But of course, the homeowner's insurance with every claim and with every lawsuit will go up a little bit, correct? Like a car insurance.
It may. If they determine that nobody was at fault, or perhaps the person that fell was at fault, perhaps they will not raise the homeowner's policy premium.
However, the homeowner's insurance company will hire a lawyer for free to defend the homeowner. And if there is a recovery via settlement or via a lawsuit, then the homeowner's insurance company that will pay Hanan, correct?
Yes. Also, I want to add one thing to the caller about you have to be careful when you receive the check for the medical bills that there is no release of liability in that release, because the insurance company may put a release of liability, and that would preclude you from ever suing the homeowner.
Okay.
And you would sign it even unaware that provision was in there.
I lost you for a second. You said if you accept a check from an insurance company, beware that it's only for medical pay, that you are not releasing all your rights out of this incident, correct?
That's right, because the insurance company may give you a release to sign before they give you the check for the medical bills, and it may contain a release of liability, which you didn't agree to. But if you sign it, you're never going to be able to sue the homeowner.
And we're going to translate all this into Arabic for a minute. And when people call us or leave us questions, if they can tell us how the slip and fall happened. We have another question. It is snow, but is it really snow? Is it black ice over snow? Is there black ice under snow? Where exactly is it? Those facts in slip and fall and trip and fall are all that matters. They can make or break your case. What did you fall on? Was it visible to your eye? What were the conditions? Was it light? Was it dark? Was it a public area? Was it a private area? It's very, very important when you send us your questions that you tell us about all this. The advice you gave is that when a homeowner's insurance company pays you for some or all of your medical treatment, they're going to send you a release. Make sure that the release has language only regarding the medical portion and not more, because if you sign a release for everything, you will not be able later, and they may be very sneaky. And we have seen this with mini tort when people get their mini tort in a car accident from the insurance company of the other car that caused damage to their car. We've seen releases. I find it very shocking. Very recently, I saw a release for a mini tort that the client of ours, very sophisticated client, very intelligent, read and adamantly refused to sign the release, and to this minute cannot agree on the language, so has not received her mini tort money yet. But they were trying to make her sign off not only on the mini tort, which is fixing her car, or not fixing her car, giving her $3,000 her car cost. It was a Mercedes, a lot more than that. But they wanted her to actually, in very tiny, very small print, they wanted her to sign off, and they wrote it in a very general way that unless you're trained, you would not know that in essence, if you sign to get your $3,000 mini tort, you can never sue the other driver for your pain and suffering. She caught it. It was sent to her before she came to us. She saw it for herself. The language made her uneasy. And had she signed it, she will have given up her right for pain and suffering. You're giving the same advice here, is that if you get reimbursed back, make sure you read what they're telling you that you are releasing. You don't want to release your ability for pain and suffering in the future. And Hanan and other people like Hanan, they have up to 3 years, Attorney Howard Radner, to sue for pain and suffering?
That's right.
Okay.
Yeah, 3 statute of limitations is correct for any negligence action against a homeowner.
Okay, thank you very much. So before we take a break, let me translate briefly into Arabic what you were sharing with us. سؤال السيدة حنان، هي عم بتزور قرايبينا وتعرضت لإصابة. سلم جدلا انه قرايبينا صار كان في اهمال من قبلهم، وبسبب الاهمال تعرضت لإصابة. عندها تكاليف ما كانت واضحة شو تكاليفها، وإنما عندها تكاليف بتحب تعرف إذا ما بدها تقيم دعوة ضد قرايبينا كيف فيها تحصل التكاليف. أول نقطة سيدة حنان، إذا كان قرايبينك عندهم هوم اونرز انشورنس، حتى سلمي جدلا، وطبعا القرار بيرجع لك، بس حتى سلمي جدلا إنه بدك تقدمي دعوة ضد قرايبينك، اعرفي إنه الهوم اونرز انشورنس كمباني تبعهم هي اللي بتوكلهم لقرايبينك محامي مجانيا. هي نمبر 1. ونمبر 2 هي اللي بتدفع بالنيابة عن قرايبينك. سو عرفي إنه المصاري إن كان ليدافعوا عن الدعوة أو إن كان ليدفعوا، إذا قدرتي ربحتي، ما رح تجي من جيبتهم هن، بس طبعا القرار بيرجع لك. تاني جزء من السؤال، التكاليف. أولا التكاليف الوحيدة اللي بهوم اونرز انشورنس ممكن الانسان يقدر يحصلها هي شيء بيسموه مد، ام لايك ماري، اي لايك اج، دي لايك دوغ، مد باي، اللي هي اختصار لكلمه ميديكال باي. شو يعني؟ يعني بالديكلاريشن بيج اللي اشتروها قرايبينك للهوم اونرز انشورنس، مثل بالكار انشورنس، بتفند شو شاريين، ولربما هن شاريين، ممكن ما يكونوا شاريين، بس اغلبيه البوليسات التامين فيهم شيء بيسموه ميد باي. بس الميد باي منا انليمتد، يعني ما فيك تتعالجي على حساب الهوم اونرز انشورنس بمئات الوفات الدولارات او حتى عشرات الوفات الدولارات. اغلبيتهم اللي فيهم ميد باي بورشن او بروفيجن فيهم لحد $1,000، في منهم لحد 2000 او 2005، في منهم لحد $5,000، وفي منهم لحد $10,000. طبعا كل ما قرايبين شاريين ميد باي اعلى، كل ما بيدفعوا بريميوم اعلى، ففي احتمال انه يكونوا شاريين $1,000. هيدا بيعني حتى لو طبابتك او الديدكتبل تبعك او الكوبي تبعك كلف أكثر من اللي هن شاريينه، للأسف الانشورنس كومباني تبعهم فقط مسؤولة إنه تدفع لك لحد هيدا المبلغ. يعني إذا الطبابة تبعك كلفت 6,000 بس المد باي هو 1,000، بس بحق لك تحصلي 1000. منك بحاجة تفرجي إهمال، لأن هيدا الجزء ما بيطلب إهمال. والشغلة الأخيرة قبل ما ناخد وقفة سريعة، الشغلة الأخيرة هي إنه إذا بعتولك تشيك معه رح يبعتولك نوع من الإسقاط الحق اللي بيسموه بالإنجليزي ريليس، ميوتشوال ريليس. بليز انتبه إنه تقري اللانجوج لحتى ما يغشوكي ولحتى ما يحتالوا عليكي ويضيفوا شي جملة بتقول إنه أنت إذا مضيتي الريليس وحصلتي على تشيك، أنت أسقطتي عن حقك مش بس للطبابة، أنت أسقطتي عن حقك كله اللي هو احتمال يكون عندك بالمستقبل، قدرتك بالمستقبل إذا غيرت رأيك، يمكن من بعد ما تسمع الحديث اللي عم نحكيه هلأ تقرري يمكن بدك تقدمي دعوة، لأنه مش رح تطلع من جيبة قرايبينك. مشان هيك العالم تشتري انشورنس، لحتى إذا مغلطين أو إذا كان في إهمال من قبلهم أو بالنيابة عنهم في انشورنس تغطيهم. مشان هيك بنشتري انشورنس. يمكن حضرتك تغيري رأيك، يمكن إصاباتك وألمك يصير لدرجة تضطري. كوني حريصة إنه وقت بتقري الريليس تمضيه وما يكون في لانجوج، ما يكون في شي جملة مش بس بتعفيهم عن الطبابة، بس بتعفيهم من إنه أنت تقدري بالمستقبل عندك لحد 3 سنوات من وقت الإصابة تقدمي دعوة عطل وضرر ضد قرايبينك. لأنه إذا قدمت دعوة، الانشورنس كومباني هي اللي بدها تدفع، الانشورنس كومباني هي اللي بدها توكل محامي. هيدي بتصير ونبهنا عنها من وقت إلى آخر. شفتها بمكتبي من شهرين ونص. اجت لعندي سيدة قبل ما تجي لعندي ضربتها سيارة ببلومفيلد هيلز، والانشورنس تبع الطرف الآخر بعت لها ريليس. سيارتها هي كانت متأذية أكثر من $3,000، باتل تورد بيقول فقط لحد $3,000. سو بعتوا لها ريليس إسقاط حق ليبعتوا لها $3,000. بالإسقاط الحق حاطين جملة، وهيدي الجملة فيها لعب شوي على الكلام، يعني منا واضحة، يعني منا واضحة وضوح كامل إنه إذا مضيتي على هيدا الإسقاط الحق بتكون هي رح تتخلى عن حقها بالمستقبل، تقوم عطل وضرر ضد السيارة الثانية. بس كانت منتبهة، قريت، ووقت اللي فرجتنا اياه اكدنا لها انه لو مضيت على هيدا الريليس وبعتته ما كان فيها بالمستقبل انه تقدم بقى دعوة عطل وضرر pain and suffering، بالانجليزي بيسموها third party case، pain and suffering case، ضد السيارة الثانية اللي هي سببت لها الحادث. هون كمان التحذير انه لازم نقرا شو على شو بنمضي، بالاخص وقت اللي بيجي من قبل انشورنس كومباني، وبالاخص وقت اللي بتيجي من انشورنس كومباني وانت ما عندك محامي، يعني بيحاولوا يستغلوا الامر. ناخد وقفه سريعه وبنرجع بنحكي عن 900 little bit less than 1000 settlement المحامي هاورد رادنر قدر حصل عليه. ما بدنا نعطي كتير تفاصيل، بس بدنا نحكي عن ظروف شوي الانزلاق وضد مين امنا.
مكتب المحامية جومانا كيروز يعلن عن استقبال الموكلين والمراجعين في العنوان الجديد 24370 North Western Highway Southfield على مسافة قريبة من موقع المكتب القديم. مكتب المحامية جومانا كيروز يتعامل مع كافة قضاياكم المتعلقة بالإصابات الشخصية من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، بالإضافة إلى قضايا الهجرة والتجنس، الإفلاس، الضمان الاجتماعي وقوانين العائلة، والاستشارات مجانية. 248-557-3645. مكاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات. قبل أن تختار المحامي الذي سيدافع عن قضيتك، دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. Your Rights مع المحامية جومانا كيروز. هذه عودة إلى برنامج Your Rights مع المحامية جومانا كيروز. أرقام الهواتف في الاستوديو 313-769-6666 519-256-1023 ودائما على الواتساب 313-327-7074. جومانا نرجع لك.
شكرا جزيلا. تقريبا بالمعدل مرة بالشهر، شهر ونص، بنكون مع المحامي هاورد رادنر اللي عنده بفتكر أكتر، دايما بغلط، يمكن أكتر من 45 سنة بعتذر خبرة بقوانين الانزلاق slip and fall و trip and fall and general negligence cases. Attorney Howard Radner, I ask you this question every time. Over 45 years of experience, correct?
That's correct.
Okay.
Actually, it's 47 now.
47 years of experience. Whoa. Okay. Congratulations. And may you have another 47. I know practicing law for you, like for me and for many people, is a passion. So I am sure that you will continue doing it because you love what you do and you are good at what you do.
Thank you. That's so sweet of you to say. I hope I deserve those compliments.
Yes, you do. Attorney Howard Radner, heartfelt congratulations to us, to you, to our injured client whose case you just settled for a little bit shy of $900,000. You know, we both know we cannot say a lot. We cannot give enough information that may tip somebody as to the identity of this person. Let's talk about the facts. Where was the negligence and against whom?
Sure. The gentleman, our client, was leaving his place of work where he was assigned to he was an engineer, and he was on contract to a big city. And he was leaving the city's building, walking towards the parking lot, walking out of the building in the hallway, when he slipped and fell on a soapy floor that had been mopped up and cleaned by a janitor, but the janitor evidently failed to put up a wet sign, a wet floor caution sign, and left a very, very slick, slippery surface with her soap and water on the floor. And he sustained a number of injuries. And we were successful. We were fortunately able to get him a very nice settlement. We sued the company that hired the janitor.
That he was working in a city building. Did you sue the city? No,
we couldn't sue the city for a number of reasons, but we could sue the janitorial service that was hired by the city to come in and perform janitorial services. And
okay. So what you determined, Attorney Howard Radner, is that the city had contracted out the janitorial service to a company. You located the company, and your lawsuit and your settlement was against that company. The company that the janitorial service company.
That's right. Yes.
Well, we don't want to say a whole lot. He was definitely injured. And it's an amazing, amazing, amazing settlement. I will only add one thing. This person was able to return to work briefly after, less than a month after. But the argument we made is that he's not able to work with the same capacity, because of a head injury on his job, right? And he is an engineer.
That's true. And then he also had injuries to his shoulders and his knee as well.
Sure, but the point I wanted to bring across here is the reason this is an unbelievable settlement is because he was able to return to work so soon, but clearly was struggling as an engineer at his work. Mm-hmm. And had you gone to trial, I assume you will have subpoenaed a number of his employers to testify as to his performance after the accident, correct?
It's possible, yeah. I mean, he only went to work for one company after he left the company that he worked for at the time of the accident, and so we would have been able to bring in the records from the current employer as well as the employer at the time of the accident.
Okay. Well, again, heartfelt congratulations, and most importantly, heartfelt congratulations to the client himself.
Thank you.
The third person himself. Congratulations. We have a question under the air, and again, we have another 35 minutes. We are talking with attorney Howard Radner, 47 years of experience in slip and fall, trip and fall, and general negligence cases. And we had a question, and anybody who wants to call 313-769-6666, and anyone who wants to send their questions, 313-327-7074, 313-327-7074. Mr. Ali suffered a slip and fall on public property. He wants to know if he can sue, given that it is public property. He apparently slipped and fell on snow that was covering black ice. So there was black ice covered with snow. He could not see the black ice because it was covered with snow. He slipped and fell, and it's public property. Do we need to know more? Do we need to know about the time of the day? Do we need to know whether the area was lit or not? Do we need to know the specific public property, Attorney Howard Radner, in order to answer this question?
Well, unfortunately for the caller, there's a governmental immunity which precludes a lawsuit against the governmental entity that owned that property. However, there is a possibility that there is a snow contractor that was hired by the public entity to remove snow and ice. And if they were negligent in failing to remove snow and ice, or in doing an inadequate or negligent job in properly removing the snow and ice, the snow removal company could be sued.
So the advice to Mr. Ali and everybody listening is, don't be quick to conclude on your own that if this is the government, we cannot sue them. Maybe that work, wherever you were, Mr. Ali, maybe you were in an area that was contracted by the government, by the city, the town, wherever it is. Maybe that's why we need a little bit more details. Maybe there was a contract. Just like with our, close to $900,000 injured client, we could not sue the city if the city's own janitorial services were performing, but we could sue and get that recovery because, lucky for us, the city had contracted out that janitorial contract. So maybe, Mr. Ali, here too, depending on where you fell. Now, why does the government, let's assume that there is no, Mr. Ali did not get injured in an area where anything was contracted out or could be contracted out. What about why is it that you cannot sue the government if you fall on their property? Is it because it's open and obvious? Is it because the government has immunity? What is it?
It's because the statute provides immunity to the government for negligence cases. There's only basically 3 exceptions to the governmental immunity. One is if it's a motor vehicle owned and operated by a governmental employee. Number 2 would be if it's a road or sidewalk defect. And number 3 would be if it's a defect in the building itself. Outside of those 3 instances, the government has complete immunity for negligence suits, and so they cannot be held liable.
So, thank you. So كقاعدة عامة الحكومة إجمالاً الجوفرمنت يعني الحكومة يعني المدينة يعني السيتي يعني الستيت عندهم حصانة بقضايا الانزلاق في 3 أشياء تستثني هيدي الحصانة يعني بتنرفع هيدي الحصانة. من الضروري جدا إنه الأستاذ علي وكل اللي عم بيتسمعوا ما يستنجوا منهم لحالهم إذا عندهم كيس أو ما عندهم كيس أو يحكوا مع جيرانهم وأصحابهم لأنه يمكن ما يكونوا يعرفوا كفاية. يمكن في رينكل بالقصة. يمكن الجوفرمنت عاملة سب كونتراكتنج لجزء من الشغل تبعها حسب وين الواحد وقع لشركة خاصة. ساعتها ما بقى في شيء اسمه حصانة لأنه نحن ما بنقيم دعوة ساعتها ضد الحكومة. بنقيم دعوة مثل الكيس اللي حكينا عنه ضد السيتي ضد الشركة الخاصة. بفتكر هون خلاصة الأمر أو العبرة من سؤال الأستاذ علي إنه دائما الإنسان يتكلم مع محامي بهذا الاختصاص لحتى خلي المحامي يقول له you don't have a case أو خلي المحامي يقول له we may be able to have a case. I will never forget attorney Howard Radner in preparing to go to law school. I was taking a preparatory I don't know what it was. It was like a preparatory class. And I remember the scenario that they posed to us. They gave us a scenario between 2 people and plaintiff and defendant or between 2 people and some as a result of negligence. And the question was, who can you sue? Who can you sue? And I remember it was by the answer to that question was you had a plaintiff, John Doe, you had a defendant, Jane Doe, and the conclusion was there was up to 7 persons and entities that could have been sued, including Jane. So the same here. Sometimes who can you sue is not the person you're looking at or the company you're looking at. It may be the company and other persons and other companies. It may be not the company, but the purpose of that question was to show that there can be multiple defendants until you know more about the facts, you know more, you may have to depose a lot of people in order to find out who really, and it may be still more than one person, let's say respondeat superior, employer, employee, so to speak, and so forth and so on. But I remember that question stuck in my head because who I thought we could sue was not even the tip of the iceberg as to who you can sue. Any comment on that?
Yeah, I mean, a common situation is when somebody would fall on the way into work. And of course, the conventional wisdom is that you can't sue your employer for negligence, so that if you fall, let's say, in the parking lot of your employer, you cannot sue for your pain and suffering, even though the employer was very negligent. Now, I had a case just like that where we actually did recover. We covered over $300,000 for a lady who broke her ankle trying to get into work on a snowy day in Detroit. And the reason why we were able to succeed is because we determined that the owner of the property was not the same corporation that employed our client. The employer had various corporations. One corporation was her employer, but another corporation was the owner of the property. So we sued the corporation that owned the property. And at first blush, many people would say, well, you can't sue for that because it must be that the employer owns the property and therefore there's no case. But in that case, in that situation, it turned out that there was an avenue for her to get compensated.
So, in other words, sometimes you have to do a little bit of digging to determine who owns certain property and or who is or whether the property is contracted out to somebody else.
That's right. And in fact, it may be the same person who owns the property and who is the employer, but for whatever reason he created two different corporations. And so that the corporation that's not technically the employer can be sued.
You are absolutely right about that. In fact, you looked at a potential case, and I don't know where it stands right now, because again, this person, much like Miss Hanan, who does not want to sue her relatives, this person does not want to sue her employer. An employee of a major hospital here, if you remember, and she had an injury in the parking lot. Mm-hmm. And she was afraid that something would happen to her job if she sued her employer because she is still working. It's been months and months, and now she's back to work or she's working. Mm-hmm. And you did talk to her and you said, yes, if the parking lot where you fell is owned by the hospital, your employer, you can't sue them even if you wanted to, because all you can get from your employer is workman's compensation, meaning about 65-70% of your wages, payment of your medical bills, and that's it. There is never a claim for pain and suffering between you and your employer, the hospital. But you stated that we can look to see whether that area, it was the covered parking structure where the employees park. You know which case I'm talking about?
Sure.
You wanted to see if it was subcontracted out by the hospital to somebody else. In that case, she won't be suing her employer. She can't be suing her employer anyhow for pain and suffering. And in that case, it will be a completely different company for her pain and suffering.
That's right.
Do you remember the facts of that case? I think it was snow and ice in the parking structure.
It was black ice on a lot, yes.
Was it a covered lot or an uncovered lot?
It was uncovered.
It was uncovered. And because of that, she sustained an injury.
Right. We were looking into whether there was any snow contractor that was hired by the hospital also to see if they could possibly be liable for this accident.
By the way, should contracts between property owners, especially commercial property owners where the public is invited all the time, and subcontractors, can they be oral? I know a contract can be oral, but does it pose problems to the owner? Does it pose problems? If you are representing the owner, do you recommend that a contract between the owner and the company to whom the owner is subcontracting the work for, say, the outside, is in writing, spelling out very clearly what the duties are on the part of the...
Right, to protect both parties, the contractor and the owner, there should be a written contract so that it spells out exactly when the contractor is required to come and when he's not required to come. Sometimes the contract will say, for instance, if there's a snow accumulation of 2 inches or more, then he has to come. So that means that if there was a snow accumulation of 1.5 inches, then the snow contractor would not be responsible for coming, therefore he should not be able to be sued. But if you don't put that in writing, then all bets are off. So it's really, I think, in the interest of both parties, both the contractor and the owner, to have it all spelled out in a contract.
Thank you very much. That was amazing information. How would a contract know if the accumulation is now 1.5 inch versus 2. 2 means they have to come and clean. 1.5 inch meaning not yet.
Typically, the snow contractors will keep on the weather station. They'll have a weather station on going all the time, and they'll be watching what the weather is doing now, or what the weather is going to be doing over the next several hours, or what we'll be doing over the next week. And that way, they'll be ready to come on the scene if they're needed.
Okay. Let's take a very, very quick break. And we have about 10 minutes. We want to talk a little bit more about what happened lately, the last month. We got quite a bit of snow and ice and people who slipped and fell and all of that. We'll talk about that right after.
مكاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات قبل أن تختار المحامي الذي سيدافع عن قضيته. دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. مكتب المحامية جومانا كيروز يعلن عن استقبال الموكلين والمراجعين في العنوان الجديد 24370 نورث ويسترن هايواي ساوثفيلد، على مسافة قريبة من موقع المكتب القديم. مكتب المحامية جومانا كيروز يتعامل مع كافة قضاياكم المتعلقة بالإصابات الشخصية، من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، بالإضافة إلى قضايا الهجرة والتجنس، الإفلاس، الضمان الاجتماعي وقوانين العائلة، والاستشارات مجانية. 248-557-3645. عودة لبرنامج يور رايت مع المحامية جومانا كيروز. أرقام الهواتف في الاستوديو 313-769-6666 519-256-1023 وعلى الواتساب 313-327-7074 ورقم المكتب هو 248-557-3645 والاستشارات مجانية. جمعنا الرجالي
كيف للمعلومات اللي حضرتك عطيتها انه ضمن تقريبا 24 ساعة بتكون هيدي الحلقة اتنزلت على اليوتيوب ليلي يحضرها من جديد. بتكون موجودة على جومانا كيروز يوتيوب شانل، واللي بيكبت على البل يعني النوتيفيكيشن هيك بيجي دايما انذار وقت اللي مننزل حلقة جديدة. ومنعلم الحلقات على شو هو الموضوع او مين نعم هو الموضوع اليوم. وبنرجع مع المحامي هاورد رادنر اللي وقت بلشت استضيفه كان يقول لي عنده 45 سنة خبرة، اليوم بيقول لي عنده 47 سنة خبرة. قضايا الانزلاق وقضايا الجنرال نيجليجنس هنيناه على التسوية الهائلة اللي جابها تقريبا $900,000 من قبل شخص من الجالية. وقع كان يشتغل لمدينة وهو انجينير، وقع على صابون ومي بس ما كان يقدر يقشع بصابون ومي على الأرض، والصابون وقت اللي نشف عمل فيلم ما كان يقدر يقشعه. بدل ما الجانيتر يحط caution sign ما محطوط caution sign، زحط إذا عدة أشياء من جسده وحتى ضرب راسه، وكانت التسوية جيدة جدا بحدود $900,000. بعد عنا 10 دقايق حتى أقل 8 دقايق بدنا نحكي شوي عن الثلج والسنو والآيس اللي صار لنا أسابيع كنا عم نعاني منها، مع إنه اليوم تقريبا عم بتطلع برات المكتب 99% من الثلج داب. هيدا ما بيعني إنه ما كان في مسار إصابات من جمعة ومن جمعتين ومن 3 ومن 4. Attorney Howard Radner, people who may be listening to us, who God forbid may have been injured on snow and ice, what is your advice to them? Obviously, it's very fact specific. Obviously, it depends if it is private property or public property. Obviously, it depends on a number of circumstances, none of which we can go into now because it's really case by case. But what advice do you want to give people who may have been injured a week or 2 or 3 or 4 weeks ago because of the snow and the ice that we have experienced?
Well, obviously, the most pressing matter would be to get prompt and proper medical treatment.
Of course, treatment. That's the most important thing. That is the most urgent or immediate thing. Correct?
Correct.
Okay.
Then, if they're considering taking legal action, they should, under no circumstances, speak to anyone about it until they talk to an attorney.
And why is that?
For instance, if the insurance company for the place where you fell calls you and wants to take a statement from you, I would advise you to decline that invitation until you speak to an attorney.
And why do you give that advice? What if this person is relaying the facts as they are or as they think they are?
Well, I mean, I had a case decades ago that went up and down to the Supreme Court of our state because of a statement that our client gave the insurance company before she had hired an attorney. And the statement was subject to different varying interpretations. And the insurance company that was responsible for the liability relied on that statement and got the case thrown out. We had to appeal it. It went to the Court of Appeals and went ultimately to the Supreme Court. All because the client here spoke and gave a recorded statement to the insurance company without counsel present. So I dealt with that case for probably 10 years. We ultimately were successful, but it took 10 years of fighting. And I always caution everybody that if you're thinking of taking any legal action, then before you start talking to insurance people, you should talk to an attorney. And you should probably have the attorney represent you when you give a statement, if you choose to give a statement to an insurance company. You know, there's no law that compels you to even give a statement to an insurance company after you've slipped and fallen on someone's property. But if you choose to do that, you should really have your attorney present when that statement is being made. That's one piece of advice I would give.
So it's good advice that you're telling us that when you are injured in a place and they come and they want you to give a statement, say it is at the TJ Maxx or at a Target or outside of Meijer or wherever, you can decline to give that original statement until you have an attorney present?
Certainly. There's no legal requirement that you give them a statement.
Now, a statement, I believe maybe it's different than an incident report.
That's right. I'm talking about where they record you over the phone, or they'll come to your home and they'll record you, or they'll write it all out for you and they'll ask you to sign it at the bottom. I'm not talking about an incident report now. I'm talking about a much lengthier statement. You have to be careful also, by the way, that you mentioned it, Joumana, about giving an incident report. Sometimes the incident report will ask the customer, let's say, to write their version of what happened. And those incident reports will be admissible in court. So anything you say in that incident report, if you ultimately sue, can come back and be used as evidence against you.
Because it is your own statement.
That's right, it is, and it's admissible in court. And now, as a practical matter, when you're on the floor in some store, and the employee comes up to you and asks you to sign an incident report, I would just say not to sign anything. Just you can tell them what happened, but not to sign anything, because you're under a tremendous amount of stress at the time, and you don't have all your senses, and whatever you write down there can be used against you ultimately if you choose to sue them.
Wonderful advice. You know, Attorney Howard Radner, we are going to rerun this show with this valuable information this Sunday at 7 p.m. It will be available on our YouTube channel, the Joumana Kayrouz YouTube channel, shortly within the next day or so. Your information today was outstanding. Thank you for appearing with us. Congratulations on your huge victory. And congratulations to the client, most importantly. and God willing, we'll be seeing you in a month or so. Tomorrow, we will be talking about bankruptcy matters with attorney Michael Bankstein. Thank you to our listeners. Thank you to those who send us questions. Rami, thank you very much. ولبكرة الله راد.
شكرا جمانة، تحياتنا لك ونشكر لكل مستمعينا حسن المتابعة. إلى اللقاء.